Amazon just suspended your product for IP violation. Whether it's trademark, copyright, or patent, your listing's down and your revenue has stopped. What are we going to do? That's what we're going to talk about in this video. My name is Mario Simonian, and I'm the founding attorney here at ESCO. And before starting this law firm, I built and sold 2 7-figure Amazon brands, exited those, and then started this law firm. That was 7 years ago. But now let's talk about IP violations. So before we go any further, let's talk about the 3 branches of IP. We've got trademarks, we've got patents, and copyrights. Let's start with trademarks. With trademarks, I want you guys to think about marketing. What do I mean? So if we're talking about trademarks, we're talking about slogans, marks, which are brand names, and then also logos. Easiest way to remember this is think about Nike. Nike itself, the name, the brand name, protected by trademark, or their logo. Their source symbol, also protected by trademark, and then their slogan, just do it, protected by trademark. So think about marketing. That's usually the best way, easiest way for non-IP people, non-IP attorneys to remember trademarks. Next, copyrights. Copyrights, think about anything artistic. In the Amazon world, really what we're talking about are product photos. Those are protected by copyright, or if we want to get a little bit more detailed, someone's product packaging can also be protected by a copyright. Last, we've got patents. Easiest way to remember that is think about inventions. If there's an invention, it's probably protected by a patent. That's a 30-second overview of IP. What we've learned in our experience is that depending on the category of seller, they'll receive different IP complaints. What do I mean? Is if you're a private label seller, it's very likely that if you're going to get any sort of IP complaint, it's going to be either a patent complaint, whether it's design patent or utility patent, or you're going to get a trademark complaint. Copyright complaints don't usually affect private label sellers or PL sellers. Why? Because private label sellers are usually taking their own photos. But that's what we've seen is private label sellers receive trademark complaints and patent complaints. Now, if you're a wholesaler, online arbitrage seller, or retail arbitrage seller, you'll either receive a trademark complaint or a copyright complaint, but not a patent complaint, because you're purchasing someone else's branded product and then selling it. So patent usually is not an issue. So just keep that in mind. But that's what we've seen in our experience. Now let's talk about how to handle trademark IP complaints. So with trademarks, the first thing you want to do is verify if the complaining party, whoever filed the complaint to get your listing or your ASIN or your account suspended, if that's the same owner as who actually owns the trademark. An easy way to confirm that is just go to the USPTO website, look up that trademark, and then you'll see who the owner is. So that's one easy way. If they're not the owner, make sure you go ahead and put that in the POA whenever you're going to go ahead and appeal this. And maybe even better, provide a screenshot or even a PDF of the trademark certificate, because on there it'll tell you who the owner is. Now, something else to keep in mind is sometimes major brands will go ahead and hire brand enforcement companies. So the email address that you may see or the person or company filing the trademark complaint may not be the same one. For example, Sony may hire a brand enforcement company to go ahead and file those. But still a good place to start is confirm whether the person filing the trademark complaint against you is the actual owner. So if you did check and the complaining party is the same as the trademark owner, then there's a couple of questions we need to look at. Number one is, are you willing to just remove the trademark term from your listing and just help, because that'll help with a reinstatement? That's number one. Number two, can you fight it? Is it fair use? What is fair use? Fair use is when you're using that in a way that's not describing the actual mark itself. For example, if I'm selling cell phone chargers for iPhones, then I have to say this is a cell phone charger for iPhones. That wouldn't be considered trademark infringement. That would be considered fair use. And this is something where Amazon's own policy provides examples. So that's something else you should also look at is, what does Amazon's policy say, and are you in compliance with their policy? And last one is the first sale doctrine. And the reason I want to leave this for the end is first sale doctrine just says if I purchase a product, I could do whatever I want with it. The brand owners or the trademark owner's rights to the trademark extinguish when I purchase it. So if I purchase my iPhone, I can do whatever I want with it. I can break it, I can go ahead and color on it, I can go ahead and sell it. But Apple can't come stop me from selling the iPhone, okay? So That's first sale doctrine. Now, when we're talking about retail, especially at large volume, there is an exception to the first sale doctrine that I'll mention, but I'm not going to go into. It's called the material difference exception or material difference. And all of that we'll cover in a separate video, but I'm not going to get into that. But those are questions that you should be asking yourself, and that's something you could address whenever you're drafting the POA. Next, let's talk about copyright infringement and how to handle those violations. So with copyright complaints, first place we want to start is to determine whether you took those photos or whether you're borrowing it from someone else. On my P&L sellers, usually this is not a problem because they'll go ahead and take their own photos, their professional photography, get that done for their own product. It's usually the wholesalers, retail arbitrage sellers, and the online arbitrage sellers that'll go ahead and have issues with copyrights. So if that's the case, then that may be a violation of copyrights. Now, next thing, let's talk about DMCA. DMCA stands for the Digital Millennium Copyright Act. And the way this works is if I file a copyright complaint against you and you realize that it's bogus, it's a meritless complaint, what you could do is file a DMCA counter notice with Amazon that says, you know what, I don't believe I'm infringing on Mario's copyright. And if he believes he is, let him sue me. Otherwise, you, Amazon, have to go ahead and reinstate the ASIN or the product listing. So then I would have, once you file that, I would have about 2 weeks to either file the lawsuit or Amazon is going to go ahead and reinstate your product listing. Now, let's talk about design patents. So with design patents, what I always suggest is go ahead and get a confidential patent infringement analysis done. What does that look like? You'll present it to a law firm such as ours, and what we'll do is we'll take a look at the patent and your product and determine if it is infringing or not. This is completely confidential between us, your law firm, your attorney, and you. From there, we can decide which approach to take. So if you are infringing, then we may suggest that we look at some sort of license with them, or number 2, maybe remove the product. Now, if you're not infringing, then we could use that infringement analysis to show Amazon that an attorney, a licensed attorney, doesn't believe that you're infringing on this patent that Amazon claims. And from there, we could escalate it through the escalation paths that I'll discuss in just a few minutes, okay? But let's also talk about utility patents. Utility patents, as some of you may know, Amazon has their own little court system called Apex for utility patents. Now, if you receive an invitation to Apex, Amazon's Patent Evaluation Express program, then that's something that you may want to go ahead and join if you don't believe that you're infringing and that you could prevail. Or you may say, you know what, let me see if I could work out some sort of licensing deal with this patent owner. Now, there will be situations where you get your product or your ASIN suspended because of a utility patent, but you never received an invite to Apex. Most of the time, the reason that will happen is because the patent owner has already been through Apex and has prevailed. And once they win in Apex, they'll get some sort of verification code that they could go ahead and submit for other similar patents to the one that they just won. So keep that in mind. So now let's talk about how you may want to fight back or you may want to cooperate. So we break this down into 3 different buckets. First one is going to be comply. So if you're infringing on a trademark, you remove that trademark from your listing. If you're violating someone's copyright, then you take down that image with the hopes of getting reinstated. That would be comply. Number 1. Number 2 would be if you want to go ahead and sort of operate with the patent or with the IP holder. What that looks like is you may want to reach out to them and try to work out some sort of licensing deal, or maybe you want to seek a retraction. The retraction letter should usually be going from a law firm, from an attorney, because law firm is going to make some sort of legal arguments, maybe something to the effect of how them filing that complaint is an interference of your contractual rights or something like that. So you want to keep that with attorneys and let the attorneys handle it, because usually those can sometimes get a lot more complicated if not handled correctly. But the third thing you guys could do is go ahead and try to appeal it with Amazon. And the escalation path that we usually suggest is the POAs, and then from there escalating into other Amazon departments, such as their legal or executive department, maybe some individual contacts within Amazon, and then also looking at the BBB, Washington State Attorney General, or maybe some other AG within your own state. Those are things that you could take, and then worst case scenario, you may want to look at a lawsuit or arbitration against Amazon. That's the escalation path of how to handle trademarks, copyrights, or patent claims. Now, here's some additional tips that we'll go ahead and provide. Number 1, you may want to talk to your attorney about either TTAB or PTAB. TTAB is the Trademark Trial and Appeal Board. That's where you would go to maybe invalidate someone's trademark. And then PTAB is the same thing for patents. Patent Trial and Appeal Board. Okay? There's no damages that are awarded in those situations, but you can invalidate someone's trademark or copyright. So make sure you talk to your attorney about that. Number 2, Amazon's intentions and their objectives aren't to help you, it's to help brands and brand owners and IP owners. So they're looking at speed where we need to be able to slow them down and have them be able to look at all the evidence that we present to them. So all the appeals that we discussed earlier need to be done strategically and knowing which department to reach out to for which type of IP. Next, we'll have some of our clients say, well, I wasn't selling the product, so I can't be infringing. But in the IP world and also in Amazon's world, as long as you're offering the product, doesn't matter if you made any sales, it could be considered infringement. So just because you listed 100 units or maybe 1 unit, but no one purchased it, doesn't mean it's not infringing. And one of the arguments that Amazon hates is, I didn't know I was infringing. Knowledge or the intent isn't required for you to be infringing. So those are weaker arguments that you shouldn't be making. Lastly, USPTO search for trademarks completely free. So make sure you do that at a bare minimum. And number 2, Google patent search, also completely free. So that's a great place for you to start. Doesn't mean you'll stop there, your research will end there. I always suggest you bring an attorney to review everything, but those are great places to start. So make sure you get that done. Hope this video was helpful. And if you have any additional questions or have any IP issues, go ahead and reach out, contact our law firm, and we'll go ahead and schedule a free 30-minute consultation. I've got the link below in the comments. Thank you.